whole purse is in there, and I had 60 grand in my purse in cash. We own a construction business, and I just got paid a lot of money. Please tell me you locked the car. He said I did. Long story short, we were leaving, and I walked out, and my car was literally parked right out in front of that door. No, it's not. And it's gone. So is my purse, so is 60 grand, so is everything.
Here is the story as the victim first told it. On January 29th, 2022, Nassau County deputies responded to a stolen vehicle call. Inside that vehicle sat $60,000 in cash, unattended in an unlocked cabin. That single fact reshapes every legal question that follows.
Purse is in there, and I had 60 grand in my purse in cash.
Open the door! I got your vehicle information added already, so we're trying to get a hold of OnStar to see if they'll ping it for us. So she's going to pull up video and see if I'm going to look at
Says
this.
at 1:28 the car was still here,
Yeah,
but within seconds of that it left.
All right. Let me see if I recognize her. That might help.
She's out front. I'm just trying to figure out at what time she went outside so I can catch her on another camera in here.
So how long was she in here?
She's been in here for quite some time tonight.
Did y'all happen to see, was there a guy with her tonight?
No, it was just her. And she was sitting out on the bench, and my husband gave her a cigarette, and they walked around the car and whatever. I watched them come inside. And when he came inside, I said, "Who is that?" She walked in behind him. And he said, "Some girl sitting on the bench, she was just talking about how nice the car was. I showed her the car, blah, blah, blah." And I'm like, "Oh, okay." And he had his key in his pocket. Well, my key is in the car because if he has his key, he can lock the car. But if you go up and touch the car, it's because my key is in there, but my whole purse is in there. And I had 60 grand in my purse in cash. We own a construction business, and I just got paid a lot of money.
Oh, my God.
Yeah. So I said, "Please tell me you locked the car." He said I did. Long story short, we were leaving, and I walked out, and my car was literally parked right out in front of that door. And I walked out, and I said, "Where the f*** is my car?" And he goes, "It's right there." And I said, "Quit playing." No, it's not. And it's gone. So is my purse, so is 60 grand, so is everything.
We got your car. Thank God it ain't.
Is it damaged?
No, they just got her arrested, so it's going to be a minute. Huh?
What did she say?
They just getting her stopped and getting arrested. I'm just letting her know so she can relax a little bit.
Where at?
Is it damaged?
On the island.
We're out on the island.
No.
Praise Jesus.
I don't, not that I know of, it's
Are
not.
they going to count her money so we know that it's there? There's a
I just got
You
the
don't know
car back.
nothing yet, okay? You don't know nothing. You're just the messenger.
Open the door! Open the f***ing door!
Sorry, sir.
Hey, hold on.
Sorry, sir. I just thought the bridge was closed and I was trying. Sorry, sir. I'll get out, sir.
Get out.
I'll get out. Sir,
Stop reaching for me.
I'm not trying to. I'm sorry, sir.
Don't move. Stop resisting.
Sorry.
Okay, listen, I'm going to pat you down. Do you have anything else on you that's going to poke me, stick me?
No, ma'am.
Because I don't want to get poked or stuck, okay? You wouldn't do that to me, right? I mean, I've known you for quite a while.
No, ma'am.
Anything on you I need to be concerned about? Am I going to find anything illegal like contraband?
The $60,000, was it in the main part of the purse?
So not the main big pocket of the purse, but there's two zippers on the front of the purse. It was in the front zipper. The customer just came and gave me that money today.
Okay, because
It was for a
all
bunch
that's
of
in there is like $150.
Okay.
So we have an idea where she went.
Okay.
We're holding that house right now and probably going to get a search warrant for it. But they've had plenty of time to
Do whatever.
do whatever. But
That's great.
we have her behind the wheel. We have all of those things. So, but this is your car, right?
That's mine and my husband's.
Okay. All right. Just give us a few minutes to finish up with this. Verify a few things at that house, and then we'll go from there. Did you find her? You've never been arrested.
She said the driver's side. I got out. I got the key in my pocket. My wife has a key in her purse. It was in the floorboard. And I got out, we got out, walked off. I forgot to lock the car when we walked off. She went back, opened the door, hit the button, cranked it up, and left with my car. I did not give her permission. I do not want her in my car.
She's
definitely not in your car.
All right, we got her.
No, but I don't want her to give them so.
Nah, she's.
No, we're way past that to be where we're at right now.
No,
While we're talking. I don't want to shut the door. All right, so I'm Deputy Jackson, Nassau County Sheriff's Office. All right, obviously I'm going to be conducting a DUI investigation based on some of my observations here, and then obviously your driving actions, okay?
Before Deputy Jackson turns to the impairment investigation, consider what Florida law says about the theft itself. Under Florida Statute 812.014, theft is graded by dollar value. Property valued between $20,000 and just under $100,000 triggers grand theft of the second degree. Vehicle theft alone qualifies as grand theft of the third degree, regardless of value. Aggregated, the loss here supports a second-degree felony charge at minimum. The suspect also faced fleeing and eluding under Florida Statute 316.1935. Penalties escalate when a marked patrol unit signals with lights and sirens, and the driver refuses to stop.
At this point, you are under arrest for fleeing and eluding, but I also suspect you to be under influence of drugs or another chemical, okay? I'm sorry, drugs or alcohol. So I'll be conducting a DUI investigation. Before we do any of that, I do have to read you your rights, okay? Like I said, you are not free to leave. So you understand each of these rights as I explain them to you?
Yeah.
Having those rights in mind, do you wish to speak to me?
Not about anything you just asked me about, no. No.
So
no.
You want to invoke your right to remain silent?
No. Not at all.
No, you don't want to talk to me, or?
No. Yeah, like, no, I don't want to talk.
Okay, cool. When we get down to the jail, would you be willing to perform the field sobriety exercises?
Sure, I guess.
Sure, so by that, I mean doing...
No.
No, you don't want to do them?
She was pressing charges on me? No, yeah, no.
No, you don't want to perform the field sobriety exercises? Okay, so you're aware that if you don't perform the field sobriety exercises, that can be used against you in court at a later date, correct?
Okay.
You're aware of that? And you still don't want to perform them?
I mean, sure.
It's a
no.
I don't know.
No, I don't know why they would inform it, so no, sorry, no.
I'm asking you, do you want to perform the field sobriety exercises? You know, the
No.
walk the line, you don't want to do any of that.
No.
And again, you're aware if you don't do that, it can be used against you in court at a later date.
Okay.
So you don't want to do it?
No.
Okay. At this point, you're under arrest for DUI, fleeing and eluding, grand theft, and grand theft auto, or grand theft motor vehicle.
For the DUI? I did the walk.
That's fine. I just asked you that 3 different times. You said no.
The body cam record ends here. The full legal analysis begins now. On the Fifth Amendment, Miranda versus Arizona requires warnings only once custodial interrogation begins. Under Berkemer versus McCarty, a traffic stop is not custody until the driver is placed under arrest. Here, warnings were read after arrest and before questioning. The sequencing was procedurally correct. The suspect's chained yes-no responses raised the doctrine of ambiguous invocation. In Berghaus versus Tompkins, the court held that invocation of the right to silence must be unambiguous. Silence alone, or contradictory responses, do not automatically invoke that right. The deputy could have exploited that ambiguity. He chose not to. Instead, he clarified until the suspect stated affirmatively that she wished to speak. That is defensive practice, and it protects the admissibility of any statement that follows. The suspect then refused field sobriety exercises across 3 separate prompts. Under South Dakota versus Neville, refusal of a chemical test is admissible non-testimonial evidence. Florida's implied consent statute 316.1932 extends the same logic. Refusal is routinely argued to a jury as consciousness of impairment. The deputy warned her 3 times before accepting the refusal, insulating that evidence from later challenge. On the Fourth Amendment, deputies froze a residence connected to the suspect while awaiting a search warrant. Illinois versus MacArthur authorizes exactly that maneuver under 3 conditions. Probable cause. Reasonable belief evidence could be destroyed, and a balanced accommodation of privacy. $60,000 in currency is highly portable and highly destructible. All three prongs are met. Forcing entry without a warrant would have risked suppression under the exclusionary rule. That single decision likely preserved the prosecution's evidentiary case. On force, Graham versus Connor supplies the objective reasonableness standard. The physical control captured on scene was calibrated to a felony stop. No excessive force is documented. Grades follow. Deputy Jackson earns a B+ for textbook Miranda procedure and warrant discipline. Points deducted for elevated language during the initial vehicle stop preserved on record. The suspect earns a D. 3 felony charges, refused field sobriety after triple warning. The victim couple earns a C+. Cooperative, but the unlocked vehicle and unsecured cash were serious risk factors. The Nassau County Sheriff's Office earns an A- for rapid recovery and warrant first posture. Lessons learned. First, never store large volumes of cash in an unattended vehicle at any hour. Second, for officers, a 5-second warning about refusal admissibility is worth hours of suppression litigation later. Third, ambiguous Miranda responses must never be treated as waivers by default. Clarify, then proceed. Fourth, when securing a location, always choose the warrant over forced entry. The delay protects the case. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.